Thank you very much, Jackie. I'll share my screen here. So as Jackie noted, I am a practicing attorney here in St. Louis, Missouri. And so although I do have some background, having written a dissertation in my JSD in comparative criminal procedure, and being enthralled by the intersectionality of comparative law and legal history centering around criminal procedure, I think I approached the conference with a bit of a potentially nuanced perspective, as again, I'm somewhat in the practicing world. But that being said, let's jump into looking at confession in criminal cases, trying to look at it from something of a comparative perspective and a historical perspective. So confession represents a moral awakening. And what I did in my paper is try to utilize Glenn's classification scheme of distinct legal traditions. And certainly this concept of moral awakening is prevalent in the Eastern traditions or approaches of Hinduism, particularly Confucianism, the Chthonic approach that all legal traditions originated from, and in the Abrahamic faiths. And it's particularly associated with the concept of apology, which is a powerful ritual, even in our secular society, in our day-to-day lives. Confession permits reconciliation between the offender and the victim, and allows the offender to reintegrate back into the wider community, and potentially to restore the offender's relationship with God in a religious context. Significantly, though, I think it also denotes submission to authority in a legal context, and hence it legitimizes the legal system and the state itself. And so confessions have always ranked high in the scale of incriminating evidence. But in the medieval era, as compurgations and ordeals came to an end and were gradually replaced, the law had to try to come up with a way to, I guess, impose or create a human assessment or human judgment in place of God's. And they devised a statutory theory of proof. And so ideally, and particularly in the continental model, while it was a very religious-based society, voluntary confession would be perhaps the highest objective. But in certain cases where it'd be very difficult to find extrinsic evidence, or in the fact where there would be no eyewitnesses to a crime, difficult as it is to catch suspects in flagrante delicto, what happens? So the law, medieval law, in its quest to find justice, as some panelists have talked about, created a series of indicia that would permit, in these extraordinary cases, let's say persuasive techniques to extract confessions from otherwise recalcitrant or unwilling suspects. And so however rare or aberrant torture may have been in the medieval era, and I know there's a lot of historiographical debate on this matter, the fact is that torture was utilized. And in the common law, in the consciousness of this, particularly from the criminal procedural perspective, it's undoubtedly influenced by the fear of the techniques created by the Inquisition, the Spanish Inquisition in particular. These three particular techniques, the Garrucha or strappado, the pulley-based system, which often dislocated limbs, the Toca, the water torture, or in modern parlance, waterboarding, and the Potro, or the rack, which of course would stretch limbs, potentially break bones. But one other thing, or one other institution, of course, that the common law, particularly in the United States, has grappled with, and it's more difficult because it occurred in the bastion of the common law in England, on English soil, is the dreaded Star Chamber. And this is manifested, of course, in the trial of John Lilburne, otherwise referred to by his sobriquet, Freeborn John, because of his assertion there were certain innate rights that humans are endowed with. And in 1637, in his famous trial, when he was brought before the Star Chamber, it really manifested the despised practice of the Star Chamber in compelling individuals to take an oath to answer the charges truthfully before being informed of the charges against them, placing these suspects in the throes of the cruel trilemma, effectively compelling them to either commit perjury, suffer contempt of court, or incriminate themselves. And Lilburn's refusal to do so, although he wasn't the first, but his refusal to do so and his invocation that this practice violated the law of God and the law of the land not only influenced the House of Commons, which ultimately abolished the practice, or the Star Chamber, a few years later, but of course greatly influenced the Founding Fathers and the drafting of the Constitution and Bill of Rights, particularly the Fifth Amendment, a century and a half later. Now, I think that's a fairly accurate assessment, but I think what this does is that it places the common law in effectively a state of chronological isolationism. We're always relitigating this history. And so the specter of inquisitorialism is ever present. As Maitland famously said, the forms we have buried, but still they rule us from the grave. And so I think that this strand of anti-inquisitorialism, as Sklansky has talked about, pervades the legal ethos of the criminal procedure in our country. And so looking through the case law, of course, there's a whole litany, I can't go through all of them, but I would like to show a few cases at the US Supreme Court that it's always juxtaposed from the common law in the United States against the inquisitorial system as practiced in the Inquisition or the Star Chamber. So in Bram, the United States, at the end of the 19th century, the court notes that the system, the inquisitorial system, was so odious that it would press the witness unduly, physically browbeat them, and trap them into fatal contradictions. It ultimately was abolished. But even into our own time, in living memory, in the mid-20th century, in Chambers v. Florida, Thurgood Marshall's, I believe his first case, before the US Supreme Court, the court noted the testimony of centuries and this great appeal to history is proof that physical and mental torture and coercion, particularly invoking the memories of the Inquisition, the rack, the thumbscrew, the wheel, have all left in their wake mutilated bodies and shattered minds. And this repetition continues into the 1960s, into the famous Warren Court criminal rights or criminal procedure revolution, where the court continually invokes the specter of inquisitorialism or the abuses suffered under those institutions. Confessions have often been extorted to save law enforcement the trouble of obtaining valid and independent evidence. A year later in Escobedo, the court noted it learned the lesson of history, that law enforcement, which depends upon the confession, in the long run will be less reliable and more subject to abuse than a system dependent upon extrinsic evidence. And this culminates, of course, in the seminal case Miranda v. Arizona in 1966, where Chief Justice Warren explicitly invoked the spirit of John Lilburn and the specter of the dreaded Star Chamber in his opinion mandating law enforcement to inform suspects of their constitutional right against self-incrimination. He also warned, of course, of a growing technique centered around psychological tactics to replace the third degree known as the Reid Technique. What's fascinating is, although Warren was aware of the history, certainly of this anti-inquisitorialism, which certainly pervaded his writing and his thinking, he did not take the step of actually prohibiting confessions altogether in criminal cases. And the Reid Technique, based on Inbaugh's method, really attempts to obtain a confession, which, as we are increasingly learning, may not always be the truth. False confessions do occur. And the Reid Company, headquartered in Chicago to this day, boasts that if this technique is successfully utilized, confessions can be obtained in 80% of cases. And this technique is, or this series of steps, is familiar to anyone who watches any type of TV show, Law and Order, certainly to this audience. And it's borne out, I think, by some research studies in the literature. Sal Cassin at John Jay College of Criminal Justice in a 2012 study, for example, noted that when he looked at about 60 false confession cases, 50 of them or so, over 80% involved mistakes, such as eyewitness errors, mistaken forensics. But the shocking aspect is that half of these cases, the confession was the very first piece of evidence collected or obtained by the interrogator, by the modern inquisitor, by law enforcement. And so this attempt to extract a confession is often criticized because it can lead to a confirmation bias on the part of the interrogator. And the database, or the data from the Innocence Project, also seems to bear this out, that of 375 people who have been exonerated by DNA evidence in the past 3 decades, somewhere between 25 to 29% of these individuals gave some type of false confession. And so it's not always they were subjected, of course, to overt physical abuse, although the Star Chamber and the Inquisition. In fact, it's far more infrequent that that occurs, especially when you can utilize the Reid technique that's widely applied throughout this country and much of the world. And so it's not for nothing that Justice Brennan, in his dissenting opinion in Connelly in the 1980s, noted that really, for all practical purposes, the real trial occurs when the confession is obtained. It renders the other aspects of the trial superfluous. And so looking at the United States today, I think it's accurate to an extent to say the common law in the United States does focus upon procedural justice. It's true. I think, as Professor Musick noted in her concurrent panel yesterday, this notion that justice must not only be done, but must be seen to be done. It pervades our ethos. But I think that's accurate much more so at the trial, at the adversarial contest, which of course happens far less frequently these days, almost nil. And so if you look at the case law, there's further case law that's undermined the holding of Miranda. If you look at the widespread application of the Reid technique and the fact that it's also estimated 80% of suspects waive their Miranda rights, in combination with the prevalence of false confessions, as noted by Cassine in the Innocence Project, I think that far from having or notwithstanding the anti-inquisitorialism that pervades our legal ethos, is it accurate to say that confession still retains primacy of place in the United States, or as that medieval term was applied to the continental model, the regina probatianum? I think a case could be made. In stark contrast, though, and to start wrapping up, I think from a Jewish perspective, it's fascinating because this tradition is very much focused on restorative justice. It believes in reintegrating the offender back into society. And so confession is integral to the system, as Patrick Glenn noted. But from a legal perspective, they developed a categorical prohibition on admitting confession in criminal cases, basing themselves on a biblical verse in Deuteronomy and the Pentateuch, or the 5 books of Moses, the Torah, however we refer to it, which states that a matter must be established by the testimony of 2 or 3 witnesses. The sages or interpreters of the law deem this to be a prohibition of divine origin, which implicitly excluded not only circumstantial evidence, but self-incrimination. And in the Talmud, the compendium that lists the codified statements or rulings of the rabbis, reflecting a much older oral tradition, this is borne out at least as early as the 3rd or 4th century of the Common Era by noted Talmudist Rabbah who lived in modern-day Iraq. And this continues on into the medieval era. Some noted scholars reaffirm this principle. Rashi, a great medieval French commentator who lived during the First Crusade, and his contemporaries in Spain, who tried to proffer rather banal explanations, not so much being a divine origin, but if confessions were permitted, as Rabbi Joseph ibn Magash said, perhaps courts could become unduly influenced and potentially disregard contrary or even exculpatory evidence. And Maimonides, a great scholar and physician, and perhaps the most noted Jewish philosopher since antiquity, speculated that confessions in this context are inherently unreliable, may very well be the subject of coercion, duress, or mental impairment. Also, I think it's worth noting that around the time of Lilburn's trial, there were Christian dissidents or Puritans who actually invoked the trial of Jesus before Pontius Pilate, as recorded in the Synoptic Gospels, as further evidence of some ancient Jewish right against self-incrimination, as stated in Mark 15, but recorded almost verbatim in Matthew 27 and Luke 23. Pilate asked him, "Art thou the king of the Jews?" And he said, "Thou sayest it." And the chief priests accused him of many things, but he answered nothing. And Pilate asked him again, saying, "Answerest thou nothing?" Jesus answered nothing. And Pilate marveled. And so in the eyes of some Christians, and I think this may also be recorded or at least hinted at in Fox's Book of Martyrs, this is not only evidence of a Jewish right against self-incrimination, but in the Christian perspective of a divine right against self-incrimination. So what are the consequences of having this categorical prohibition? Well, as I said, Judaism does emphasize the confession, but it views the courtroom, the legal process, as the inappropriate venue. Jewish courts were spared an extraordinarily time-consuming and fact-sensitive process of evaluating the voluntariness of confession, which occurs all too often today in our criminal justice systems. And lastly, and perhaps most significantly, coercion was somewhat abolished because confession played no role. So there would never come a time when the courts would attempt to compel or coerce a confession from a suspect. And torture is virtually unknown in the annals of Jewish legal history. So in conclusion, ladies and gentlemen, why study comparative legal history? Well, I think Lord Bingham, the former Chief Justice of the United Kingdom Supreme Court, I think gave two great reasons. The first is that in no other field of human endeavor, whether it's medicine, art, music, literature, science, do we reject ideas simply because they're of foreign origin. But perhaps more importantly, we tend to think, he said, of each of our legal traditions as a purebred, homegrown product, indicative of a national genius. But the truth is otherwise. Legal traditions have influenced one another and continue to do so. And I think there's one more reason, and this is me as a practicing attorney, that as a practicing attorney, and I think this was also noted in potentially one of the plenaries yesterday in the concurrent sessions, but as a practicing attorney, we tend to look, of course, at precedent and stare decisis. So history is important, but it confirms the current result. And so Edward Cope famously did this. Being a practicing attorney, he started in the present moment and read backwards. And so, of course, starting at the end and reading to the beginning confirms the inevitability of where we ended up. It doesn't really allow, I think, for alternative paths, the path not taken. And so, though we can only conceptualize the past ultimately by living in the present, I think let us begin by looking in the beginning and not at the end. And that's, I think, the benefit, really, of engaging in an analysis of comparative legal history, that it can shed light even on some of our problems and issues and debates in the modern day. Thank you.
Thank you so much, Isaac. I turn to our next speaker, who is Claudia Passarella.
Thank you very much. So my paper focuses on trial by jury in Italy between 19th and early 20th centuries. The research has been carried out by adopting a comparative approach with special attention to English experience and French tradition in the late modern period. As well known, English and French juries represent two essential reference models on this matter. Both systems, indeed, greatly influenced the development of jury trials in Europe and beyond. The history of trial by jury in the Italian peninsula begins in the mid-19th century. Jury trials were introduced in 1848 only for press crimes. In 1859, however, the institution was extended to many other criminal behaviors. A few years after the unification, the legislator approved the first Italian Code of Criminal Procedure. Such a code provided that the most serious crimes were to be tried at the assize courts, composed by 3 judges and 12 jurors. At that time, trial by jury was the subject of an extensive debate between those who defended the institution and those who strongly criticized it. According to the former, jurors gave voice to public opinion and performed an undeniable social function. According to the latter, trial by jury must be abolished because a criminal judgment should not be demanded to incompetent people without any legal knowledge. From their point of view, the jury was an exotic institution imported to Italy without taking into account the legal tradition of the country. The Italian jury system, indeed, was patterned on the French model. This means that Italian juries had inherited both the inconveniences and the weaknesses of the French experience. Even those authors who tenaciously defended the institution admitted that the regulation of the matter should be improved. It is in this spirit that in June 1874, the legislature approved an extensive reform which brought significant changes to the way by which jurors were selected and operated in the trial. Hereafter, the Italian jury assumed a more precise physiognomy, thus emancipating, at least in part, from the French model. The reform concerns every aspect of the system: the jury selection process, the role of the jurors during the trial, the relation between jurors and judges, and the way by which the verdict was issued. All these aspects must be examined by adopting a comparative approach. The Italian jurists themselves, in their works, proposed a detailed comparison between English tradition and French experience in order to investigate positive and negative aspects of both the system and propose the best possible solution. Here, I want to focus my attention on the jury selection process, because the jury selection process represents the cornerstone of the whole system. As pointed out by an eminent legal author of the time, Giuseppe Pisanelli, the provisions on the composition of the jury are to be considered as the very foundation of the institution, so that an imperfection in them informs all its other parts and produces serious and unavoidable damages. My analysis will be divided into 4 sections. I will examine, first of all, the choice of the best eligibility criteria to serve as jurors in criminal cases. Secondly, the procedure involved in preparing jurors' lists and panels. Thirdly, the practice of jury challenges. In the last part of my relation, I will deal with the problem of non-attendance of jurors by analyzing some funny episodes which took place at the beginning of the 20th century. To serve as a juror in a trial, a person needed to meet certain requirements. In the long 19th century, English jurors must be qualified with respect to property. Behind this rule, there were 2 distinct but connected reasons. On one side, an economically prosperous juror might be less tempted by bribery and corruption. On the other side, the property qualification secured the jurors' attendance, because a man of property was more easily punishable by fine. The eligibility requirement established by law ensured that English juries were drawn from a top few percent of the population. In France, the system was based on partially different assumptions. The law enacted by the French legislature in September 1791 equalized the role of the elector and the responsibilities entrusted to a juror, although the former was a political office and the latter a judicial duty. According to the law, only citizens who enjoyed high wealth condition could become electors, thus only people who enjoyed an economic prosperity could serve as jurors. At first, the Italian legislature followed the French model. Therefore, the names of the jurors were to be drawn from the electoral lists. The reform enacted in June 1874, however, abolished the parallelism elector-juror and introduced the so-called system of categories. Henceforth, a man could become a juror only if he belonged to one of the categories established by law. There were 21 categories in all. The first 20 included, for instance, lawyers, notaries, schoolmasters, university professors, doctors, and so on. The policy was to admit as jurors people whose abilities were certified by virtue of their education or occupation. The currents of the system, however, risked to be seriously compromised by the last category, which included people who paid a certain amount of taxes to the state treasury. Some authors agreed with this legislative choice. Without the addition of this category, in fact, it would have been difficult to have a sufficient number of jurors to meet the demands of justice. Other authors, by contrast, believed that this solution would have deeply altered the logic of the system. The reform indeed, on one hand, aimed to identify intelligent and competent jurors based on direct evidence of ability. On the other hand, called for jury service people who enjoyed an economic prosperity without any added proof of competence. Such a critical remark, however, was destined to remain unneeded. The second stage of the selection process consisted in the preparation of jurors' lists and panels. In this respect, the English system attributed extensive powers to the sheriff. The sheriff had to return a competent number of good and lawful men of the body of the county qualified as jurors according to law. There were no specific criteria used to make the selection. The choice was left to the sheriff, who usually summoned 48 persons at assizes and 36 at sessions. On the other side of the channel, the French legislator attributed an important role to the appointees of the central government, especially the prefectural authority. As you can understand, such a system ensured a significant governmental influence in the selection of jurors. The Italian procedure was originally patterned on the French tradition, with particular reference to the role assigned to the prefects. The reform introduced a new system of selection based on the work of 3 different commissions. The most important was the 3rd commission, composed by 2 judges and 3 provincial councillors. They were entitled with the power of excluding those persons who were unsuitable for jury service, as though formally belonging to one of the categories established by the legislator. As we have seen, indeed, the categories listed by law, especially the last one, provided only presumption of ability which could have been disproved by evidence. The final step of the selection process involved the use of challenges. The right to challenge was traditionally seen as a vital aspect of jury trial. The jurors, in fact, were not only to be qualified and competent persons, they should also enjoy the full confidence of both the parties. In the common law tradition, challenges were classed into 2 distinct groups: challenges to the array and challenges to the poll. Challenges to the array were an exception to the whole panel, motivated by the bias of the person responsible for making the selection, so the sheriff. By contrast, challenges to the poll were challenges addressed to a particular juror. They could be peremptory when the challenging party did not give any reasons, or for cause. Peremptory challenges were reserved for defendants. Prosecutors, indeed, were endowed with the so-called stand-aside power, which meant that the Crown might exclude unsuitable jurors without hearing any reason. This power was unlimited and, for this very reason, subject of criticism. In this matter, the French legislation was much simpler than the English one. The system was based on 3 principles. First of all, in France, the legislator allowed only individual challenges. This type of challenges appeared to be a sufficient guarantee against suspicion of bias. Secondly, the distinction between peremptory challenges and challenges for cause was not contemplated in France. In the French system, indeed, the individual challenges were rigorously peremptory. Thirdly, the use of this prerogative was equally shared between both the parties. The prosecution and the defense counsel, therefore, had an equal number of challenges. Also, the Italian law provided only individual challenges, but those challenges might be either peremptory or for cause. Challenges for cause could be exercised in order to exclude specific categories of jurors, among which relatives of the parties, witnesses in the case, or anyone else had played a role in the investigation. The right to challenge must be exercised on the day of the trial, after the judge had ascertained the presence of 30 jurors at least. But the jurors' attendance cannot be taken for granted. In everyday practice, in fact, a significant number of jurors failed to appear. The absenteeism was punishable by fine, but the penalties imposed to law seem to have been an ineffective deterrent. Sometimes the summoned jurors answered to the call, but asked to be exempted due to medical or professional reasons. At the beginning of the 20th century, we find a great number of cases in which Italian people tried to escape jury service, especially in long and complicated trials. By analyzing the case studies, we understand that potential jurors appealed to the entire pathological encyclopedia in order to be exonerated. For instance, in a trial held at the Court of Assize of Turin in 1904, most of the jurors claimed to be suffering from prostate hypertrophy. As written by a national newspaper, in such a case, the jury bench would look like a school children for which a natural urge becomes an excuse for leaving the classroom. In another famous trial, 3 potential jurors claimed to be suffering from neurasthenia. One suffered from hysteria. Another one felt a sense of oppression associated with breathing difficulties, while the third was claustrophobic. There was even a juror suffering from an invincible intestinal disorder. They exhibited a medical certificate to prove their poor health conditions, which prevented them from serving as jurors in the trial. The exam of the documentation took a long time, and the proceeding was affected by a considerable delay. Sometimes the judges spent all days in the composition of the jury. This is the case of the so-called Cuoccolo trial, a very famous trial in the Italian system. On June 1906, Gennaro Cuoccolo, an inside man of the Camorra, and his wife, Maria Cutinelli, were found dead near Naples. The investigations continued until 30 suspects were committed for trial. The trial took place 5 years later at the Court of Assize of Viterbo in the Lazio region. The proceeding moved from Naples to Viterbo to avoid local interests, which could compromise the serenity of the judgment. The citizens of Viterbo, however, did not want to serve as jurors in this trial, and when the selection of the jury began, they engaged in a giant stampede. Numbers speak for themselves. Of 50 jurors summoned, 48 failed to attend. A national newspaper paid special attention to this episode by noting that the risk of summoning provoked a real terror in the population. Some persons locked up themselves in their houses, thus the bailiff could not deliver them the summons. Others left the city. A respectable professional went so far as to disguise himself as a farmer in order not to be recognized on his way to the station. Faced with this situation, the Deputy Attorney General appealed to the citizens' responsibility so that the trial could begin. However, 4 days must pass before the procedure for the composition of the jury was finally complete. As shown by the Cuoccolo case, the jury service in popular opinion was often perceived as a burdensome duty rather than an opportunity to make a contribution in the administration of criminal justice. Potential jurors did everything they could to escape this troublesome office, usually because they did not want to be distracted from their business for a long period of time. Online, I found an early 20th century postcard which represents the same juror on the first and last hearing of a trial. In the first picture, he looks like a young and vigorous man, while in the second, he is depicted as an old bearded man. This picture clearly demonstrates how long a trial lasted and how much this affected jurors' lives. The problem of non-attendance of jurors existed also in other countries, for instance in Scotland or in Ireland. From this point of view, there is no real difference between common law and civil law jurisdictions. In all countries which experience trial by jury, the rules of law have to deal with harsh reality. The ideal goal of the legislation was to find a number of qualified and competent jurors able to fulfill their duty with seriousness and impartiality of judgment. In everyday practice, however, such a purpose was very difficult to achieve. Thank you for your attention.
Thank you so much. We go now to our next speaker, Kevin Davis.
Great. Thank you, Jackie. It's a pleasure to be here. So this paper is actually more of a methodological paper than one about criminal law doctrine. It's really about how we should go about the project of comparing law, of doing comparative law. So even though the illustration is based on the laws that govern homicide, the argument actually applies to any kind of comparative analysis. So the core of the argument is based on a single insight. Basically, in a globalized world, people and activities in any one place are going to be influenced by legal norms that emanate from a variety of sources, including sources outside the territory of those people, right? So basically foreign law matters, transnational law matters. And the argument which follows from that is that if we want to understand the relationship between law on the one hand and social outcomes on the other hand, we we have to take into account more than just the local law. We also have to consider extranational laws. Now, there are three ways in which I suggest that extranational laws can influence outcomes locally. Two of them I think are quite familiar to all of us. So first of all, foreign laws can influence local law through the operation of public international law or through local adoption of foreign norms, through transplants or diffusion or translation or whatever you'd like. So that's one channel, and that's when it's basically adopted. Secondly, foreign laws can apply extraterritorially, like when the Foreign Corrupt Practices Act applies extraterritorially to a foreign firm. So that's US law applying extraterritorially, right? And I think both of those channels of influence are very familiar to comparative lawyers and scholars of private international law and public international law. The third channel I don't think has attracted quite as much attention, which is when foreign law actually applies to people or products or capital in the territory governed by the foreign state, but then those people or things or capital move across borders, right? And so through that channel, through those cross-border flows, the foreign law actually impacts what's happening locally. And I think an example, one of the few examples of work that's really focused on that channel is Anu Bradford's work on the Brussels effect, which refers to the way in which EU law influences people around the world by regulating goods and services that move across borders. But I'm going to offer a very different example of, I think, or set of examples of the same kind of phenomenon. Because I think the argument that follows from the insight that extranational law has these kinds of influences locally is that if we want to understand, again, the law in any one society, we have to take into account all of the laws that affect people in that society, both local and foreign. So I illustrate the argument using a case study from the Caribbean, and I should explain why the Caribbean. It's basically because I wanted to make life as easy for myself as possible. I figured that's where I'd find the best possible evidence in support of this argument, because the Caribbean is a region that's buffeted by foreign and supranational laws. First, you've got the legal relics of colonialism through transplants and supranational courts like the Judicial Committee of the Privy Council. So that's the sort of local adoption of foreign laws. You've also got a certain amount of extraterritorial application, simply because the Caribbean is in the backyard of the United States. So that's another feature of the Caribbean. And last but not least, the Caribbean countries are very open to trade and immigration and cross-border flows of capital because they are small island economies, many of which aspire to be financial centers. So within the Caribbean, I focus on Jamaica and a particularly sad feature of Jamaica, which is its exceptionally high level of homicides. And I think that's a sufficiently important social phenomenon that it's worth trying to think through, well, how does law affect it? And that seems like the kind of question that comparative law lawyers might ask. To what extent is the homicide rate in Jamaica influenced by legal variables, let's say, as opposed to culture or economics or demographics or some other non-legal variables, right? So that's the idea. And my argument is really drawing on a work that a lot of social scientists have done about the determinants of homicide in Jamaica. And the factors that they identify are not purely domestic. Obviously, factors like demographics and poverty and inequality and rates of urbanization are important. And they've also identified various features of the way the police force operates as being drivers of crime and homicide in Jamaica. But those don't seem to explain why Jamaica is such an outlier in the region, or globally, really. It actually has a significantly higher level of homicide than you'd expect, given those characteristics of the society. And I think at this point, it might be helpful to share my screen, because if I can find this, although it seems to have disappeared, I'll leave that. At one point I had PowerPoint here, but it's no longer there. Okay, forget about the chart. It's one of the top, the most violent, homicidal, shall we say, societies in the world. Usually vying to be number among 3 or 4. And the factors that people have identified, you know, going back in time, they started with political factors, right? In the 1960s, when Jamaica became independent, it actually wasn't very violent. The rate of homicides was comparable to the United States or Canada, right? Around 4.6 per 100,000, right? Since then, it's gone up to around 60 per 100,000 at its peak, with a dip in 2010, and then more recently, it's gone up again. So what happened? First, there was a lot of political violence in the 1970s. And then, starting in the 1980s, you had the drug trade, right? Which I think of as being driven to a certain extent by extra-national factors, in particular, US drug policy, the war on drugs, driving up the price of narcotics, both marijuana and cocaine, and then US enforcement practices that over time shifted flows of cocaine from, say, Central America over to the Caribbean, including Jamaica, which became a significant transshipment point. So those laws, US laws, drug laws, and the ways they were enforced, I think actually ended up driving a lot of the crime in Jamaica, which involved conflict over the proceeds of the drug trade. Right? Okay, so those are the drugs. Guns, another factor. More than 80% of the homicides in Jamaica are committed with guns, and the vast majority of them are imported from the United States. There was one point in 2009 where a study found that almost the majority of the guns that were seized in Jamaica were actually coming from just 3 Florida counties. 3 counties right around Miami that happen to have large Jamaican populations, right? And lax gun laws. It was very easy to buy guns, even legally, and then export them to Jamaica. So US gun laws, another factor. Deportees. What are deportees? These are people who've been deported from countries like the US, the UK, and Canada, often for committing crimes, not necessarily serious crimes. And that's been another important factor, according to some people, in driving levels of crime in Jamaica. I should say, it's not clear whether the deportees are the perpetrators or the victims of the crimes, but there is a correlation between the volume of deportations to Jamaica and the rate of crime. And it's a significant volume. There were 45,000 people deported to Jamaica between 2000 and 2014, most of them coming from the US. There was at one point in 2016, the estimate was that 2% of the population of the entire island was actually criminal deportees, which, if you pause and think about that, that's a significant influence on society. And that is driven entirely by immigration policies and the ways and laws in countries like the US, the UK, and Canada. Okay, so those are the deportees. If I were able to show you the chart, the slide, you'd see that the crime rate, the homicide rate in Jamaica peaked in the first decade of the 2000s and then dropped sharply in 2010 and stayed low, remained low for the next 4 or 5 years. What happened there? It was a single incident, actually. It was the extradition and capture of a single drug dealer named Dudus, who was sought for prosecution in the United States. The Jamaican government went into his hideout in West Kingston, launched an assault with 800 soldiers and 370 police officers, supported by a US drone, went in and captured him, also killed 69 civilians, and 3 police officers also lost their lives. And then after that, the power of the gangs in that part of the city was significantly diminished, at least for a while. And as a result, and I think there's a consensus about this, the homicide rate dropped. Right? Again, that was an intervention, a single enforcement action that was driven entirely by a foreign actor, in this case, the United States, seeking extradition, right? And as a consequence, literally hundreds of lives were not taken, I should say, over the course of the next few years. Finally, I'm sad to say that in recent years, the rate of homicides has gone up again, and most of it is driven by conflict over the proceeds of telemarketing fraud. Right? Or they call you up, try to sell you, tell you that you've actually won the lottery. That's the most common fraud. Get you to send money to somehow cover the costs of collecting your winnings and so forth. This is big business in Jamaica. It's not just the Nigerians who do this. And so in the western part of the country, where people used to work for those telemarketing organizations, the legitimate ones, they've actually, a lot of people have shifted into the business of this telemarketing fraud. And a lot of the homicides that have followed have been fights basically over the proceeds of those frauds. So that seems to be driving a lot of the crime in Jamaica. But fluctuations in the level are being driven in large part by international collaboration between the Jamaican police force on the one hand, and US and Canadian and UK police forces on the other hand, and prosecutors, which have tried to crack down, and also compliance policies of international companies, the money transfer companies like Western Union and MoneyGram, which have put controls on the remittance of the proceeds of fraud, well, all sorts of funds to the island. So that's the case study that I use to suggest that there are some very important ways in which extranational laws could influence an important set of outcomes in a particular country, like homicide levels in Jamaica. I don't think you can find a more important set of outcomes than that. And I think it's fairly clear, building on the work of the social scientists, that it's not just the Jamaican legal system that's driving that, right? It's also aspects of the legal system in the US, the UK, and Canada. And it's not just the laws on the books in those countries, but also the ways in which they're enforced. I think this is relevant to comparative lawyers who are interested in conducting causal analyses. This is something we do. We try to compare laws, say Jamaica and Barbados, to figure out, well, is it the legal system that explains why Jamaica's homicide rate is so much higher than Barbados's? My point is that if you're going to undertake that kind of comparison, you have to look at not just the national laws of Jamaica, but also the set of foreign laws that happen to influence the homicides in the country. I basically am advocating for what I call a subject-based approach to defining the relevant set of laws, as opposed to a source-based approach, which would say, well, you just focus on the laws that come from the national source. And this obviously has implications when you're thinking about possible legal reforms as well, whether you should focus on improving policing or introducing the death penalty in Jamaica, or considering reforming deportation practices in Canada, for instance. So that's the paper. I think I should stop there, and I look forward to questions.
Thank you so much. Now I'm going to ask people to raise their hands electronically, not to use the chat function, but to just raise their hands electronically through the raise hand function at the bottom of your screen. And that way I can see the hand next to your name and can call on you. So any questions? I don't see any. Let's see. If you're having trouble raising your hand, you can also speak up. If and I'll just, I can also take people who just unmute and say, I have a question. So I'm going to ask the first question then. First, for Claudia, I have a question about the Italian jury system. There is, of course, still a tradition of having mixed panels of lay and professional jurors in Italy today. Now, what's interesting is that Italy has adopted an adversarial system of criminal procedure in many respects, but that has not extended to the jury system, right? So the criminal procedure system has that was adopted in 1988 was very much inspired by the adversarial system. But my understanding is that the jury system was not brought in from the adversarial system. And by contrast, you have places like Spain, which have not generally adopted an adversarial criminal process, but which have adopted a jury system that's more based on the Anglo-American model with lay jurors who deliberate on their own, even if they interact with the judge before rendering their verdict, and the judge has to approve their verdict and can send it back up to 3 times. So I wanted to ask you to kind of disaggregate for a moment the jury aspect of the system from the adversarial system, and stepping back to a comparative perspective, what do you think might drive a system to adopt an adversarial criminal procedure without the jury system, or vice versa, as in Spain, to adopt a lay jury system without necessarily adopting the rest of the adversarial criminal process?
Yes, it's true, because jury trials in the Italian system were abolished under the fascist regime. So in 1931, and when jury trials were abolished, they were replaced by a system of mixed courts. So now we have this principle of cooperation and collaboration between judges, professional judges, and lay judges at the Court of Assizes. The problem, we don't have introduced again jury trials because we have 2 principles in our Italian Constitution. In the Italian Constitution, there is the principle of lay participation in the administration of justice, but there is also the principle that all the judgments are to be motivated with the explanation of the reasons of the judgment. And this principle is considered in contrast with the jury trials. So the reason we have decided to maintain the system of mixed courts, because there is this rule in our constitution, and the rule is considered in contrast with jury trials. So 30 years ago, we have changed our criminal procedure, adopting the adversary model, but jury trials were not introduced again for this reason, in my opinion. And I think that the introduction of the adversary model is very important, and is better to have abandoned, to have change from the inquisitorial procedure to the adversary model. Also, if we don't have jury trials, because we have, in any case, we have lay participation in the administration of justice in a different form. So I think it's a compromise solution, but it's not so terrible. Jury trials had positive aspects, but also negative aspects. So maybe mixed courts could be a solution, a compromise solution with all the problems, but it's a compromise.
I understand, thank you. Let's see, again, I want to see if there are any hands, people I can call on. And if for some reason, did I see a hand? Oh no, that was my own. Kevin, did you can you unmute yourself?
Yeah, hi. I actually had a question for you, Jackie.
Yes.
Because you're saying that in the U.S. there was it was almost like a public-private partnership. There was the collaboration between the state and private undercover investigators, and that was encouraged. But I guess as I was trying to think about stories I've heard about private investigators and so forth. Not necessarily, well, I think it's in the criminal context or with a view to trying to uncover at least illicit activity. I'm thinking about the cases of animal rights organizations trying to infiltrate either factory farms or meatpacking plants. I'm not sure if they're trying to uncover criminal activity, but sometimes I get the sense they are. But there's also been pushback by industry on the part of industry, and they've used legal tools actually to do that, to sue for trespass and possibly even more. So I was just wondering if you could speak about that phenomenon, which seems to be the opposite of the main phenomenon you're describing. This is a case where the private sector is actually pushing back against against private efforts to undertake investigations. And since some of those, I would imagine some of those industries are operating on a multinational scale, I'm just wondering if you know if they're doing that in other jurisdictions as well.
Great question. Yes, in my paper, I actually differentiate between a variety of modes of interaction between private and public sectors. One of them is for the state to delegate certain powers. That happened more in the 19th century when the state didn't have really any federal police force at all. And so it hired the Pinkertons to investigate. The Secret Service hired the Pinkertons. Later on, it hired William J. Burns. These are all private detectives. A post office hired Pinkerton as an investigator. But the model of partnership that I spoke of later in World War I was really one where the federal government not having the means to crack down on prostitution itself relied on moral purity societies to do that. I see a question. Well, afterwards, I will call on the person who just sent me the chat. But so yes, that's one mode of interaction, is for the public sector to delegate, as it did in the anti-prostitution efforts of World War I, and as it did in the 19th century for certain specific tasks. But there were many interactions in which the private sector actually either circumvented the state, did things that the state didn't want to do, as in corruption investigations, and in particular, during the Progressive era, it was the private sector that cracked down on dance halls, on saloons, on leisure establishments of all sorts, because of liquor violations, because of prostitution, because of efforts by elites who did not approve of the leisure establishments frequented by immigrants, and who wanted to shut them down, and did so by withdrawing liquor licenses. And often these private agencies were promoting an agenda of total suppression, either of brothels or of liquor establishments. And they succeeded to an extent in that Prohibition, in a sense, grows out of those private reform efforts. And those private reform efforts were, for a long time, very antagonistic to the police, very antagonistic to municipal governments. They also tried to do something about the municipal machines, the democratic machines, whom they believed were to be complicit with the vice providers in the cities. And so these were by no means being utilized by the state. What they did, though, eventually is acquire enormous political influence. For example, by drafting vice reports, by visiting red light districts all around the United States, and then writing semi-official reports based on their undercover investigations of the conditions in the brothels, in order to create public outcry, in order to influence the public enforcement agenda. And that is still what we see today in many instances. The animal rights groups are pursuing precisely that agenda, raising awareness of a particular problem, either because there isn't enough legislation or because it's not properly being enforced. So horrific conditions in slaughterhouses are constantly being unveiled by undercover investigators inside these establishments to show what factory farming really looks like. and in order to work up a response to this. And an enforcement agenda. We see something similar actually in the movie I just saw 2 days ago, The Infiltrators, activists who are pointing out the hypocrisies of the immigration system by infiltrating a prison, an immigration prison, and showing that the people who are being held there many times for years are people who have not violated any laws and who are not criminals, and who are low priority, even though the administration at that time was saying that they would not hold low priority people who were eligible for deportation in immigration prisons. And again, the agenda there was to draw attention to it, to create a kind of groundswell of political movement in order to change things. So I think that use of privileged insider accounts comes from the progressive era, really, although it's older than that, but it was mostly mobilized then by these elites outside of power. Elites only in the sense that they have a cultural voice that's being heard, they are amplified by the media, and there is a political constituency for their programs. And so you have undercover tactics in the progressive era and today still being used to show up people in power, to show up the failures of enforcement of the existing administration, and to change those practices. Now, I saw someone had just sent me a note that they were not able to raise their hand. Let me see, that was Athena Stafila. Can you unmute yourself and then you can ask your question?
Yes, thank you.
Hi.
Hi, I don't understand why I don't have the video, and
I'm sorry.
I don't understand why the host prohibited us to use our video anyway. So
I don't know.
Thank
That was
you.
me.
I know, of course, I know. Big thanks to all the panelists for a very informative evening. And I have here some questions on criminal process. It's not the jury, but it's the confession and the prohibition of torture. It was very, very illuminating, all these historical remarks of Mr. Amon. And I want to say here that we have, during the era of the Enlightenment in Italy, with Cesare Beccaria on crimes and punishments, the first Enlightenment theories against the torture and against these confessions, because these were taken and they were probably false. All the facts confessed, everyone understood, were confessed because the accused persons were under the terror of the torture and admitted everything, although they knew that nothing existed. They said it to escape the torture. So after this Cesare Beccaria theoretical essay came his grandson, Alessandro Manzoni, and he wrote a very famous literature work castigating confession and torture, La storia della colonna infame, the story of the column of infamy, and then later Pietro Verri, Osservazioni sulla tortura. So all these Italian theorists of the Enlightenment era played a great role, just for your historical research. And my question is, do you believe that the international law these days have to play a role on that matter? We have so many human rights conventions, regional human rights conventions securing the rights of the accused. And the criminal systems, the national criminal systems, sometimes react in a very negative way. What's your experience? What do you expect? What do you think it has to be done now? At what level, international or national, to come to many countries to a good result of not admitting confessions and torture in a criminal process? Thank you very much.
Thank you.
Well, thank you for the question. It is complex. I mean, at a certain level, of course, as you said, you know, we do have certain conventions, such as the Convention Against Torture, and I mean, I think the great success at the international level, I think, is that most countries today, and I forget the exact number if they're all signatories to that treaty or convention, but that no country overtly says they're torturing anymore. They'll cloak it with euphemisms, and so I think the legitimacy of torture has certainly, I mean, vanished, I would think. We know, for example, that it's ongoing in certain countries, North Korea, other places in the Middle East, perhaps, or elsewhere, but no country is really willing to acknowledge. They deny that it's done. So I think that's a great success. I think, though, you know, in the current situation we have in 2020, of course, particularly with the let's just say the response of certain countries to the views of international law, particularly in the criminal context, the ICC, I think this has to be almost a grassroots approach, or maybe a bottom up as opposed to a top down. That in terms of legitimacy, there is a pushback from nation states against international law. So while I would like, of course, countries to ratify the Rome Statute, including our own, I don't see that happening anytime soon. And the fact that China, Russia, I think India, they were just unwilling to take that final step. So I think that in terms of this question of confession, and I might add though, I don't know how many people would agree that. I mean, I've tried to argue maybe that the Western legal tradition, particularly the common law, can learn from the Jewish model. And should we come to that point to just prohibit confessions entirely in criminal cases, particularly in capital cases? I mean, you either have extrinsic evidence or you don't. And the fear that, you know, the confession, if that's the only evidence, I think we've arrived at a point that we should extend Chief Justice Warren's reasoning from Miranda and prohibit confessions. But I think there's a lot of education to do in that realm. So I think we have to do this on maybe a country by country basis or a legal tradition, and through education, through teaching, and through spreading the word. I mean, and I'll just add, you know, in my conversations, in my time in The Hague, I've also studied a little bit abroad at the Sorbonne. I've been in Portugal. I've spoken with various actors and participants in these criminal justice systems, not to mention alone at the federal level here, the state level. They're all very interested, I think, in this idea. So I think if we can just kind of keep the lines of communication open, but work on it from a state-by-state basis, this is our best option right now to try to advance the cause and really, as I say, cast confession into the dustbin of history, or at least coerced confessions.
Thank you so much. We have just a few minutes left. I'm just going to take the 2 questions, and then that way we at least can collect the question and see how much time there is for an answer. If you can just briefly say your questions, Mariano Sicardi and Liliana Sanchez. First, Mariano.
Sorry, Liliana. Well, my question was for Isaac, but he already asked with the previous one, so I skipped.
Okay, thank you. Liliana?
Thank you all for the presentations. It was a very interesting panel. And I have a question for Kevin. And I agree that foreign law influence local outcomes in some countries. However, I have 2 questions regarding the case study. The first one is related to war on drugs. War on drugs is a very strong case of influence of the United States in many countries, mainly in Central America and in South America. And drug and guns are completely related. So taking into account this context, my question is, to what extent the results of this case study can be generalized, or if it is possible to say that this case can be biased because this very strong situation with war on drugs. And my second question is if you include some variables to show like the position or the status of the countries, the foreign one and the local one, and the terms of the relationship between these 2 countries.
Hi, Liliana. Sorry, I can't see you. So thanks for the question. On the first question, yes, I think the study is completely biased in favor of my conclusion. But not necessarily for the reasons that you give. The intention was to create a best case for the hypothesis by looking at a country that was influenced strongly by a bunch of external factors, right? So that was quite deliberate. It's sort of a proof of concept kind of thing. So in terms of case selection, it's about it's the best case scenario, right? To illustrate the concept. But I don't think the war on drugs is the only driving factor, because the case study includes at least two other factors that aren't really that connected to the war on drugs. Or the associated flows of guns. First, the telemarketing fraud, which is actually the principal driver of homicides right now, and has been for the past 3 or 4 years, really isn't about the drugs. I guess you could argue that the guns that are in the country were there because of the drug trade, perhaps, so there is that connection. But no, I think the telemarketing fraud aspect of the study is quite separate from the war on drugs. And the same would be true to a large extent of the deportation, right? The effect of deportees. Some of the people being deported from the US, the UK, and Canada were deported for drug crimes, but often there were immigration violations or other sorts of crimes. So I think those two variables, if you were, or those two themes of the case study are quite independent of the war on drugs and are not biasing it in that direction. So, so that's that. I wasn't sure I followed the second part of the question, but I see we're short of time, so maybe we can talk offline about that. So I'll defer to Jackie on that question.
Well, yes, we are unfortunately out of time, but thank you so much to our panelists, to our audience for coming, for asking questions, and for a great panel. Thank you so much. And I hope we can see each other in person very soon. Take care. Bye-bye.
Yes, thank you.
Thank you. Bye.
Thank you. Thank you. Bye-bye.
Bye-bye.
Oh, Claudia, are you still there?
Yes.
Oh, maybe could I email you? I had some follow-up. It's me, Isaac. I had
Yes,
some
yes.
follow-up questions for you on the jury system in Italy.
Yes, of course. So my email is, you have to, Claudia Passarella is my name and my son.
Is it full name? Is it the straight?
Yes, Claudia Passarella, yes.
Okay.
86.
86.
Yes. At gmail.com.
Okay, so Claudia Passarella 86 at gmail.com.
Yes, perfect.
Okay.
I think I can find your email online, maybe, you know, so we can.
Yeah. I'd like to keep the correspondence going, the dialogue, the conversation.
Yes, of course, because I found very interesting your paper. I studied the confession and torture in the Republic of Venice in the modern period. So me too, I have lots of questions about your topic. So very, very good.
Okay, perfect. So I'll reach out. Okay. Grazie
Bye.
mille. Bye. Bye.
Bye, bye, bye.
Bye.